Hello, everybody. Look what we're talking about today. How to control a witness using leading questions. Here we go. How to control a witness using leading questions is my topic for today. And now we're going to show you my fancy ticker tape. Here we go. Ready? How to control a witness using leading questions. Not direct questions, not open-ended questions, but instead leading questions. That's exactly what we'll be talking about in today's video. Here we go. How to control a witness using leading questions. Stand by while we get ready to get started. How do you like that? My fancy ticker tape, better than any 3D graphic. By the way, this is 3D, in case you can't tell. This is a 3D graphic. Notice the 3 dimensions on how to control a witness using leading questions. That's exactly what we'll be talking about. That's exactly what we will be talking about in today's video in this beautiful day here in Great Neck, New York. All right, it's a gorgeous day today. It is the 16th of May, 2017, and now here I am outside shooting video. It's a bit very, very sunny, but today we're talking about how to control a witness using leading questions. Stand by as we get ready to get started. All right, so let's get started. Hi, everybody. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And today you know the topic already because you've seen my fancy ticker tape. It's how to control a witness using leading questions. So now, how do you do that? So the scenario is that we are at trial, and now we have an opposing witness on the witness stand. Let's say it's a medical expert. It's a medical malpractice case. And now, what happens? So now, if I were to go ahead and ask the defense's medical expert to go ahead and tell me, why, doctor, why do you think we don't have a case? What do you think he's going to say? He's going to go ahead and give a long-winded explanation to tell me exactly why we don't have a valid case, according to him. And that's the dilemma with asking an open-ended question for a medical expert who is opposing our particular case. So on cross-examination, you never, ever want to go ahead and ask an open-ended question. That'll kill your case, because anything that the defense, anything that the witness will say, you know is going to come back to hurt you. So instead, what do? Instead, we use short, direct, leading questions. So what exactly is a short, direct, leading question? I'll give you an example. Doctor, isn't it true you graduated medical school from this medical school? Yes. Now that is a direct question. He can either say yes or no, or I don't know, or I can't answer. 4 options. Doctor, isn't it true you then went on to do an internship at this hospital? Yes. Isn't it true you then went on to do a residency? Yes. And in fact, you became a chief resident. Isn't that true? Yes. And after graduating residency, what did you do? You then went on to become licensed to practice medicine in the state of New York. Isn't that true? Yes. So again, today we're talking about how to control a witness using leading questions, which is critically important for cross-examination. All right, so here I am going through the basic doctor's credentials. Doctor, isn't it true that after you became licensed to practice medicine, you then took 2 years in order to obtain your case list, in order to apply and sit for the board examinations? Yes, that's true. And that means that you have to accumulate a certain level of experience before you are permitted to go ahead and take your board certification. Isn't that true? Your board certification exams. Isn't that true? Yes. And in your specialty, you have to take not only a written part of the exam, correct? But you also have to take an oral examination. Isn't that true? Yes. So what have I done right now? So I've asked a series of leading questions that call for yes or no answers. Each of these questions are very short, they're very concise, and they ask for 1 fact per question. That's exactly how you control a witness on cross-examination. I don't want to go ahead and say, doctor, isn't it true? Or better yet, I don't want to say, doctor, tell me about your credentials. And now the doctor will go on and on for 10, 15 minutes talking at length about all the great places he studied and all the training that he received. And now he comes across as very educated and very knowledgeable. That's not what I want to accomplish. During cross-examination, my goal is to go ahead and tell the story for the doctor. I want the doctor to either agree with me or disagree with me, because in today's video, we're talking about how to control witnesses using leading questions during cross-examination. That's the goal. If you cannot do that, you're going to have a big problem as you try and control the witness, because you know he's going to go ahead and start pounding you over and over again every time he's allowed to explain anything. So the better practice is ask short, direct, leading questions. Doctor, isn't it true that you saw my client on January 1st? Yes. And on that day, she complained of having a lump in her breast. Isn't that true? Yes. And on that day, you did a physical examination. True? Yes. But before doing a physical examination, isn't it true that you took a history? Yes. And you would agree, doctor, that taking a history is vitally important? Yes. And it's important. Now, I could say, doctor, tell us why it's important. But instead, I'm saying, doctor, it's important because you know that a patient's medical history is critically important to help you understand what problems the patient is having, so it will help you better recognize what problems and solutions you have in order to treat this condition. Isn't that true? Yes. So my goal when I ask leading questions is to really make a statement. Let me say it a different way. I'm either asking a statement, I'm either making a statement or I'm asking a question. And the statement I'm making is a factual one. Doctor, isn't it true you saw my client on this date? It's either yes or no, right? I don't want to turn around and say, doctor, when did you see my client? Because now he could say, well, the patient made an appointment on this day and then called up and had to cancel, and now she made it on a different. Now he goes off on a tangent, giving information that nobody needs to know. It's not important. So instead, what do? We ask short, direct, leading questions that now goes ahead and controls the witness. And let me give you another example. When it comes time to ask a doctor, whether it's an expert or the doctor whom you have sued, opinion questions to give his opinion and conclusions about the improper medical care, now this is a key strategy, this is a key opportunity to go ahead and ask leading questions. Doctor, I'm going to be asking you a series of questions that call for yes or no. If you can answer those questions yes or no, do you promise to tell me yes or no? And if you don't know the answer, do you promise to tell me I don't know? Yes. And if you cannot answer the question because of the way I've asked it, do you promise to tell me that before answering that question? Yes. So those questions, those statements that I've just made, are designed to get the doctor to acknowledge and to recognize that that's all I want from my questioning. Yes, no, I don't know, or I can't answer. That's all. And if the doctor sticks to that, he's not going to have a problem. However, you will know that even the best doctors, even the best attorneys who prepare their clients for questioning during trial, they have a very difficult time getting them to stay on target with those 4 answers. Now, if the doctor tries to go off on a tangent, I'm going to bring him right back. Say, doctor, I asked you a few moments ago whether you would go ahead and answer my questions yes, no, I don't know, or I can't answer. Which one of those 4 is it? And I told you that if you can't answer the question, simply tell me that and I'll ask another one. You promise to do that, right? Yes. Fine, let's go back to my question again. So now, in these hypothetical questions where I'm trying to get the doctor to admit or to acknowledge that he did something wrong, I now have an opportunity to ask hypothetical questions. And again, the hypothetical questions are direct questions, direct leading questions. Now, I'm going to set the scenario. Doctor, on January 1st, when Mrs. Jones came in to see you, you performed an examination. Isn't that true? Yes. Now, I want you to assume that she told you she had a lump in her left breast at the 12 o'clock position. Assuming that fact to be true, would you agree that it is good medical practice to go ahead and take a detailed, thorough medical history before doing a physical examination? Yes, I would. Doctor, would you also agree that after the patient complained of having a breast lump at this location, that good medical practice requires that you do a physical examination? Isn't that true? Yes. Okay, so what am I doing? I'm leading the doctor down a series of steps. And doctor, I want you to assume that the patient complained of this breast lump at this location. And now I want you to assume that you have taken a thorough history. And now that... No, let me go back. Doctor, I want you to assume that the patient has complained of a breast lump at the 12 o'clock location and now has given you a detailed history. You would agree that a doctor who fails to do a breast examination at that point would be a violation from the basic standards of medical care, correct? Now he has to answer either yes, no, I don't know, or I can't answer. If he answers, I don't know, he looks like an idiot If he says, I can't answer the question the way you asked it, now I'm going to ask it a different way. Doctor, would you agree that good medical practice requires that when a patient goes ahead and makes a complaint of a breast lump, good practice is to go ahead and do a physical examination of the patient at some point during your visit? Would you agree? Yes. And failing to do that breast examination would be a departure from good medical practice. True? So what have I done? I've simply turned the question around. At first, I asked him the question of what is good medical practice? And then I turned it around by simply saying, hey, what's not good medical practice? And he has to answer, yes, it would not be good medical practice if the doctor did not do a physical examination. So, assuming in this case that one of the claims is that the doctor failed to do a breast exam, this is a series of questions that I would be asking. So let's take a quick water break for a moment. Okay, so how do we control this type of witness? By asking him short, leading questions, where I am putting words into his mouth, and I'm simply asking for yes, no, I don't know, or I can't answer the question. So let's take this even further. Doctor, I want you to assume that further facts are to be true. Now, of course, when I ask such a question, I have to have a good faith basis upon which I'm asking that, right? Those facts have to be supported in the medical record, in the testimony, the pretrial testimony that has been given in this case already. And now, based upon that information, that those facts are favorable to us, I'm now asking the doctor to actually assume that those facts are true. Now, I know that the doctor does not want to admit and acknowledge that those facts are true. In fact, they're fighting us on those specific facts. And that's why he will go ahead and do everything possible to say, I can't answer that question. I don't like the way you phrase that question. Whatever question I ask, the point is, when I ask it based on a series of facts and asking him a hypothetical question, they must be based on facts in the medical record. Otherwise, I'm going to get an objection from my opponent who now says, objection, Judge, those facts are not present in the record. That's not what's happened in this case. And now I'll get an objection. The judge will agree with him, and I'll have to ask a different question. So I'll go back and ask more hypothetical questions. Doctor, I want you to assume that now the patient returned to your office 3 weeks later, and on that visit she again complained that the lump being larger. Would you agree that good medical practice requires that you do another physical examination? Yes, it would. And would you agree that good practice requires you do a physical examination of her sitting up? Yes. And also laying down, correct? Yes. And that's important for you to do, correct? And would you agree that the failure of a physician to do a physical examination, both sitting up and lying down, in that instance on a follow-up visit of a patient who complained of a breast lump, that would be a violation from the basic standards of medical care? Objection, Judge, he can't ask that question. Objection overruled. Sit down, defense counsel. Judge, and now, doctor, go ahead and answer the question. So the doctor has no choice but to answer these questions because they are short, concise, leading questions, which is the exact way on how to control a witness during cross-examination. That's your goal. That's exactly what you want to see here. Okay? If you go into court, or you're a litigant, and now you see an attorney asking an opposing witness an open-ended question, doctor, tell us why. Why did you do that? Or why was this done? Now you can basically pull whatever hair you have left out and ask yourself, why is he asking an open-ended question? I will tell you something. There are some really good attorneys who ask what we call throwaway questions. They turn around at the very end of their questioning, and they don't care what the answer is, but they just want to make the point by asking the question. So they will turn around and say, hey, you know what? Doctor, tell me why this happened. And they don't care what the answer is, and they're basically turning away from the doctor and walking away. That's a throwaway question. If they don't care what the answer is, it doesn't matter. They've made the point by asking the question. But you will find that the best trial attorneys do not do that on a regular basis. Instead, the best practice is ask short, direct, leading questions that call for yes, no, I don't know, or I can't answer the question. Getting into verbal arguments with the witness is not going to help, and besides, you're going to be at a disadvantage if you have not taken steps at the very beginning of questioning to go ahead and get the doctor to promise me that he's only going to answer my questions yes, no, I don't know, or I can't answer. Because if you don't ask those series of preliminary questions, now I'm getting into a verbal sparring match with the doctor The defense attorney is going to be jumping up and down like a yo-yo, objecting. The judge is now going to be ruling. Now I'm going to have to change my questioning. And guess what? Now the jury is going to think that I'm arguing with the witness for no reason whatsoever. And it makes no sense. So instead, the better practice is get the doctor to admit and acknowledge that he will answer the questions that way. Otherwise, he's going to look unreasonable. And make sure you ask short, direct, leading questions. And that will be the way that you control witnesses on cross-examination. Well, I hope you found this video informative. I hope you found it useful. And if you did, what I encourage you to do is share it on your Facebook feed. Or if you're watching this on YouTube on the replay, then I invite you to like it and also share it with your friends so they get the benefit of seeing all this great information as well. You know, I realize you're watching this video because you have questions or concerns. Actually, that's not true. I realize you're watching this video on Facebook because it's coming up in your Facebook feed. And now you'd stop to watch for a little bit, and hopefully, again, this was interesting and entertaining. Now, if you're watching this on YouTube and you have questions, or actually, no matter where you're watching it, if you have questions about your matter that happened here in New York, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207. It's like follow the bouncing ball, right? Or by email at Gerry, there we go, at Gerry@Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day, everybody. Bye-bye.